All right. Please have a seat. We are back on the record in State versus Inland County.
All right, the state has had its say, so Mr. Sawyer.
Judge, good afternoon. I can't, begin to understand or, the experience of pain that the family is feeling. Terribly, terribly sorry for the Drusba family and for Mrs. Drusba. I just, for the record, I wanted the family to understand just some things from our perspective. At the beginning of this case, the state asked for conditions of release, and I'm not sure if it was your honor or another judge imposed conditions of release. And the best way to go to prison for a really long time is to violate your conditions of release, as your honor well knows. I guess we could have come back to the court and asked to change the conditions of release. I didn't think about that at the time. Maybe it's made me a little wiser. Maybe I've learned a little bit, but certainly the family has wanted to throughout. I've tried to express their feelings to the state throughout, and certainly Mr. LaBounty throughout has wanted to express his genuine remorse. Upon my advice, because conditions of release, you cannot use third parties in any way to express your sentiments. I advised Mr. LaBounty and his family time and time and time again that I was sorry, but that they could not reach out to the Drusba family. I discussed this with the state. So Mr. LaBounty and his family have wanted to reach out a number of times, and that did not happen. And as Ian's counsel, I now see the path would have been to request your honor to change those conditions. If in fact the Drusba family wanted to receive contact, I didn't do that. It's something that through years and years and years of practice, I've always been pretty stern with clients about not violating their conditions, because inevitably clients violate their conditions. And so I think that this situation was very unique, and I apologize for me not seeing that was important. And I'm sorry for that. Mr. Drusba came forward early in the case and discussed the case with the state and told them what he was looking for. After that, the state makes it an independent determination on their own. There was never any no jail offer, just so Mr. Drusba understands that just did not exist. So, but I know how much strength and courage that took, and I can understand how upset that would make everybody feel when something like that is rejected. From a defense perspective, what I also think is that sometimes it takes people a while to come to terms with what's happened. We're not all emotionally intelligent, super emotionally intelligent individuals. And when there's a trauma involved, the gravity of it is like something like this. Many of my clients never get there. They never accept responsibility. In my humble opinion, Ian has. It took a while to where he could get there to realize that the gravity of what he did. And I think it's a process. And in my opinion, Ian's gone through that process He has worked with a counselor. He's read the letters again and again and again and tried to work through them with Mr. Steinbauer. I think Ian is pretty unusual as far as a defendant. A lot of my clients, have records and have committed crimes and are prone to committing crimes. Ian is very different. He has a good family. He has good family support and family ties. He has a good upbringing. He is an intellectual. He's a musician. He's a community member. He's volunteered with the Knights of Columbus. And he's somebody who made a terrible, terrible, terrible mistake that he could never, ever take back. And he's very sorry for that. There's nothing we can do or say. I think we all want something good to come out of this, and has expressed from a very early stage that he wants something good to come out of this. His willingness to tell others to not do what happened to him, about the impact that his act caused your family. So just looking at the statutory factors, Judge, family ties, if a person has good family ties, they're unlikely to commit additional crimes. And he's got all kinds of family ties, Your Honor saw through our memo. He's had consistent employment, another factor. For recidivism is employment. He's been consistently employed. That hasn't been the issue as well. I think all we're, talking about here in some ways is retribution. And I don't know that that there really any counseling at all inside that's gonna do anything for him. So what we're really just talking about is just pure jail time, just kind of dead time. And I understand there has to be a punitive response. And I think that just about every client, but to write a sentencing memo and to acknowledge that he needs to go to prison, that he needs to leave his family, leave his girlfriend, his house, his job, everything else, it doesn't make up for anything. But to write a memo and approve a memo with 2 years, where we're asking for 2 years, the vast majority of defendants are going to be asking for no jail time. We didn't ask for that. We thought a couple of years was more appropriate. So he is here for a grossly negligent operation, death result. He did not admit to being under the influence of drugs. He admitted to taking the drugs, falling asleep, and being grossly negligent, resulting in Ms. Drusba's death. I think I'm going to let Ian talk. He has indicated a willingness to do community service, certainly to do continued counseling around any drug use and emotional issues. And we would request a couple of years, maybe like a 2 to 10 split to split, with probation, drug counseling, community service, presentations to schools, colleges, etc. That's all I have, Judge. I think Ian would like to read his statement that he made.
Thank you, Mr. Sawyer. Mr. Labonte.
Good afternoon, Your Honor.
Why don't you stand up?